It's a notepad. It's All right, excellent. It looks like we're live and ready to go. So good afternoon, everyone. Today's Friday, February 26th, 2021. We have 5 bills on the docket. We are going to quickly go to Senator Gazzone because I know he's going to get right back, and then we'll go right off to the Attorney General. Mr. Chairman, we'll start off with you with Senate Bill 144. We'll then go to the Attorney General 530, 524, and then we'll move to 535. And we'll end up with Senator Zucker with 592. So, Mr. Chairman, you're up.
Thank you, Mr. Chairman. This bill is about vehicle recharging statements for electric vehicles, and particularly as it relates to the need for those charging stations in multifamily communities where they're condominium or homeowners associations. I mean, it's not lost on any of us. We talk about it all the time, sort of the movement to energy efficiency, and this, I believe, is just an attempt to help catch up with that. Folks who live in a community like that where there are designated parking spaces or deeded parking spaces, they may not easily or immediately, the community may has not dealt with the idea of providing charging stations. So what do we do about that? What about individuals who want to purchase electric vehicles? My first jump into public service was the chair of an 11,000 member community association some years ago. And we always were trying to balance the desires and interests of the individuals with the needs of the community to protect its interests. I believe this bill does that as it relates to recharging stations. So it sets up a process whereby individuals who want a charging station and would like to have it installed at their deeded or designated spot can work through an architectural review process, which is pretty standard for these associations. The idea is sort of the way to sort of work through this as both sides are cooperating. On the one hand, the HOAs or community or condominium associations would be required to take action on this within a reasonable period of time, either yes or no. And the flip side for the community association, for the individual, is that they would be responsible largely for making sure that this worked. Their particular charging station. In other words, and it lists out in the bill things like it has to adhere to the architectural standards, they have to engage a licensed contractor, they have to pay for the electricity usage that's associated with the meter. They have to cover the cost of installation, maintenance, they have to cover insurance and name the association on the insurance policy too. So I believe it's a pretty thoughtful way of helping folks who have and want electric vehicles to get a charging station installed at the site of where their car is. There are some provisions that relate to some government programs, and actually I have an amendment that was worked out with the Hogan administration, and you, I think, have both the amendment and a letter from the Maryland Energy Administration that says that with that amendment, they actually are favorable with this bill. So pretty pleased the administration agrees. This is a good plan. As you may know, there is about $1.2 million in the budget for this, and that's how it relates to that program for recharging equipment rebate program. With that all being said, I would hope a favorable report. Thank you, Mr. Chair.
Excellent. Thank you, Mr. Chairman. We'll now move on to you have two witnesses on your panel, and we'll go to Ms. Gala first as the primary, and then we'll toggle over to Mr. Hartman.
Good afternoon. My name is Stephanie Gola, and I'm here to discuss my experience with requesting approval from my homeowners association in order to charge my electric vehicle. I live in a townhome community located in Anne Arundel County. Each unit is assigned 2 parking spaces. A sidewalk is directly in front of the parking spaces, and a grass area is in between the sidewalk and my townhome. On November 3rd, I placed an order for an electric vehicle. I mentioned it to my next door neighbor, who is a board member of the HOA and head of the Architectural Change Committee. He asked how I planned to charge it, and I stated that I would plug it into the outlet on the outside of my home. He stated that an electrical cord crossing the sidewalk was a trip hazard. I noted that there are many people in the community that run water hoses and vacuum cleaner cords across the sidewalk. I then mentioned that I could have a pedestal charger installed in my parking space, for which the electricity would run underneath the sidewalk, alleviating the trip hazard. He said that the county doesn't allow that, and that he knew that because another resident had requested installation of a charger the previous year. He also mentioned to me that it could potentially interfere with other utility lines. I decided to call the HOA manager to get his initial thoughts. He stated that running a cord across the sidewalk would be a trip hazard. When I mentioned the water hoses and vacuum cords, he stated that they were only temporarily there and that people were physically with them, so that it wasn't the same thing as an electric charger cord. I mentioned the installation of a charger in the parking space, and he told me that kids could get electrocuted by it, and he doubted that the board would approve it, but that I should submit the architectural change request and he would forward it to the board. I wanted to gain as much information as I could in order to preemptively answer any questions that the board may have. I contacted the county zoning and permits department and was informed that this was a private court, so I would just need to go through the HOA and not the county. I contacted an electrician who did a pre-assessment of my request, provided a quote and description of the process to include arranging the electrical permit and the inspection. He assured me that it would not interfere with other utility lines and that it was weatherproof and that people could not be electrocuted. He provided me with pictures of charging stations that they'd previously installed. I also verified that the charging station would be covered by my homeowner's insurance policy. I noted the length of the vehicle so that the charging station would not cause the vehicle to protrude onto the street. On November 11th, 2020, I submitted a 35-page packet to the HOA manager containing emails, pictures, and points of contact for the aforementioned items. I also provided examples of state and local agreements and incentives toward advancing EV infrastructure to include the dedicated web pages of BGE, the Maryland Energy Administration, and Maryland EV, and that Maryland is one of 15 states to have signed a multi-state zero-emission vehicle memorandum of understanding. I took delivery of the car on November 28th, and I was using the supercharger location closest to me in order to charge the vehicle in the meantime. However, the owner's manual states that the use of superchargers is not recommended for regular charging as it degrades the range and life of the battery. I reached out to the HOA manager on December 4th, and he told me that he put a letter in the mail for me the previous day. He said that the board needed more information, but that he wasn't prepared to discuss it at that time, and if I could call him back on the 7th. I received a letter dated December 1st, expecting it to state what information was needed. However, it just said that more information was needed and that the request would be tabled at that time. I called the HOA manager, who provided me with some of the concerns of the board, which were that property values would go down, that they were afraid of children running into it, and that I would have to remove the charging station if I sold the home. He said there were 2 other concerns, but that he couldn't remember what they were, and that he would call me back that night or when he remembered. He also asked me to provide proof that my insurance would cover it, which I emailed to him that day, and that I would need to get letters of approval from my neighbors. I asked if I needed the letters from adjacent homes or those across the street or both, but he did not know the answer to that and said that he would get back to me. I did not hear from him. A few days later, I received a letter dated December 12th that my request for installation was denied due to 2 reasons: the large amount of construction in the common area with a third-party contractor, and that a number of board members voiced their concerns about having a vehicle charging station in the front of any unit. I spoke to my neighbor, who stated to me that several neighbors had previously requested to route their sump pumps to the front of the unit, but that they were denied, so it would be unfair to allow me to dig up the pavement for this after denying them. He stated that they would look into getting a charger for the community, but that there were other projects that took higher priority. At that point, I thought that it might be acceptable to charge using the outlet if I removed the trip hazard. I purchased an electrical cord cover that was black and had yellow reflective striping.
Thank you. Just a brief moment to conclude, and then we'll move on to the next witness. So thank you very much. Okay, excellent. Thanks. So we'll now move on to Mr. Hartman. Thank you.
Thank you, Mr. Chairman. The nature of electric cars is that they usually get recharged at night while we sleep. A charging station like this can replenish about 25 miles of range per hour that's plugged in. Now, there are fast chargers along major highways like Ms. Gullah talked about. It's not really acceptable to use them all of the time. If General Motors is going to build only electric cars like they say they're going to do in a few years, then we need to figure out ways for more people to charge their cars at home. I think this bill is a great step in that direction. Other nearby states like Virginia have already adopted laws like this. And the legislation has already passed in the House. So I respectfully ask this committee to move a favorable report. Thank you very much.
Excellent. Thank you, Mr. Hartman. So with that, that'll conclude the testimony for Senate Bill 144. I'll now move to the committee for questions. Seeing none, that'll conclude the hearing for Senate Bill 144. Thank you, Chairman Gazzone. All right, we'll now move on to Senate Bill 530 with the Attorney General. Mr. General, you're up. Welcome back to the committee.
Thank you very much, Mr. Chairman. Hang on a sec. It's a pleasure to be here. Appreciate your attention on a Friday afternoon. You guys are working hard. I'll try to be quick. This bill does three things. First, it raises the filing fee for eviction cases from $15 to $120. $120 is close to the national average. We have seen various estimates of what that is. I think now it's probably $112. That's per the Princeton University Eviction Lab. The second thing the bill does is that it prohibits the landlord from passing the cost of the filing fee along to the tenant. And the third thing that it does is it takes the additional revenue that we expect that will be raised by this increase, it devotes it to the Maryland Legal Services Corporation. As you know, they were suffering this past year from a precipitous drop in revenue. The reason we need this bill is because we have an extraordinary number of eviction filings in Maryland. One of the reasons we have so many is because it's so cheap. We are literally tied for 48th place. Only Nebraska and North Dakota have lower filing fees than we do in Maryland. And we have more eviction filings per capita or per rental unit than almost every other state. We have about 660 eviction cases filed in each year. 2020 was obviously an exception because of the moratorium and the pandemic. But the filing rate, that is the number of cases per the number of rental units, exceeds 100% in a number of jurisdictions. And only a small fraction of these cases result in actual evictions. In Baltimore City, for example, in 2016, they had 125,000 rental units, but roughly 140,000 eviction cases filed. Only 6,500 actually resulted in eviction. And so the question you would ask is, why does that happen? Well, we know one property management company that files, if the tenant has not paid the rent, they file an eviction case on the 6th every month. They have tenants who pay the rent every month on the 10th. They get paid on the 8th or the 9th. The landlord files on the 6th anyhow. The question is why they do that. And the answer in part is because it's so cheap. Property managers consider eviction filings, and this is a quote from one of them, easy, cheap, part of the rent collection process. The cheap fees allow the landlords to use our district court as a collection agency. And now if I could ask you to turn your attention to the PowerPoint, if we could go back to, let's go back to slide number 2, if we could. Slide number 2 shows that the nationwide average is 112. Maryland filing fee is $15. Baltimore City, there's an additional $10. If you could move to slide 3. Okay, so this slide shows you the eviction filing rate in Maryland every year from 2000 to 2016. And as you can see, it's almost always in the range of 80-something%. In 2016, it was almost 84%. And contrast that to the national filing rate. This is what happens in other jurisdictions, an average of across the country. It's in the range of 6 to 7% compared to our 80%. If you could move to the next slide. This shows you in 2016 what the filing rates were in some of our, in the ones with the top filing rates. Baltimore County was worst, 147%. Prince George's County, 124%. Baltimore City, 103%. Wycomico and Hartford were also extraordinarily high. This is in 2016. If you could move to the next slide, please. So this shows the eviction filing rates in our neighboring jurisdictions. And I believe these are filing rates for a period later than 2016. It's done by the Princeton University Eviction Center. And you can see that West Virginia is 4.4%. Pennsylvania, our whole northern border, 5.3%. 16 times higher in Maryland, 17 times higher in Maryland. And of course, in the rest of our neighboring jurisdictions, it ranges from 12 to 16%, way, way lower than us. Now, if you could move to the next slide. This is the 2019 Maryland eviction filing rate. It went up from 84% in 2016 to 92.5% in 2019. We have a very serious problem in our state. Every time a landlord files one of these actions, it is a huge issue for the tenant. They have to take a day off of work if they can possibly arrange it, and go to court. Then they try to make an arrangement with the landlord to pay the past due amounts. The cost of the court fees, the cost of attorney's fees, the cost of agent fees, and other charges off at late fees get added to their rent, and it's extremely costly and extremely burdensome. And it's just not necessary. The reason this is happening in large part is because, as I said, of the $15 charge. And we believe, if you go to the next slide, this is just a summary, I think, of everything we've said. This bill would raise the, it refers to House Bill 729, the cross file, raise the fee to $120. It will slow down and perhaps deter the serial filings that we get every month in Maryland, and it will devote the additional money to the Maryland Legal Services Corporation. If I have some time left, I want to just address what the opposition said in a couple of instances in the House. They're concerned about small landlords. They say, well, I'm not so sure that it's small landlords who are filing every month, because it puts a burden on a landlord to do this. And if you have a big operation, it's easier to do. But the fact is that I think most small landlords do not file against their tenants every month. And if they really need to throw somebody out and the cost goes up by $100, it's worth it to get that tenant out of there. It's not a huge expense. The landlords say this is a huge jump. It's unjustified. It's unwarranted. In fact, the opposite is true. They've been getting away with a very and extremely low discount rate for decades. And it's time to bring Maryland in line with the rest of our neighboring states, the rest of our states across the nation. I would note that the District of Columbia is tied with us in 48th place right now at $15, but they are about to raise their rate to $100. Their Superior Court is going through the process to make that rule, asking for comments as we speak. So we think this is fair to the landlords. It's fairer to the tenants, and it will alleviate a big burden on our district courts and on tenants who suffer from these serial eviction filings. Thank you very much, Mr. Chairman. I hope you'll give it a favorable report.
Excellent. Thank you very much, Mr. Attorney General. Always good to see you back in JPR. We'll now move on to we'll go on to Ms. Ehrlichman. You're up next.
Thank you, Chairman Smith, Vice Chair Waldstreicher, if he's here, and the rest of the committee. I appreciate the opportunity to speak today in favor of Senate Bill 530. My name is Susan Ehrlichman. I'm the Executive Director of the Maryland Legal Services Corporation, the agency that is designated to be the recipient of the funds raised by this bill. The Maryland Legal Services Corporation was created by the Maryland General Assembly back in 1982, along with the state's Interest on Lawyer Trust Accounts program, so that all Marylanders, low-income Marylanders needing civil legal aid would be able to access those services. In 1998, back over 20 years ago, recognizing that the IOLTA program, which consists entirely of interest income, was a very volatile funding source, the Maryland General Assembly identified filing fee surcharges as another significant revenue source for our state's legal aid delivery system. We currently fund 36 organizations throughout the state of Maryland. Last year, these programs served over 182,000 Marylanders who needed help with evictions and foreclosures, unemployment insurance, food stamps, protection from domestic violence, a variety of matters that impact basic human needs, and unfortunately that have been greatly exacerbated by the COVID-19 pandemic. As these needs are skyrocketing, as you heard from our Attorney General, the Maryland Legal Services Corporation has suffered a tremendous loss in our ability to fund these programs. The Interest on Lawyer Trust Accounts program consists, as I said, entirely of interest income. Interest rates fell to almost zero. We have lost 70% of that revenue. Likewise, the revenue that we do get from our current filing fee surcharges has also plummeted, given the impact COVID-19 has had on the courts with closures and a decrease in filings. This resulted in the MLSC board having to make the very difficult decision back in June of cutting grants by 9% at a time when the needs were growing exponentially. But that wasn't nearly as bad as things looked a couple of months after that, when our income continued to decline, but for emergency funding from our state's Attorney General's office and our governor, we would have faced a devastating situation in this current fiscal year. And we dodged that bullet. And I again want to so thank our Attorney General and our governor for that funding. But that helped this year. And if we don't find additional funding for fiscal year 22 and beyond, we're going to be in a dire situation again. Enactment of Senate Bill 530 would not only eliminate the necessity of further cuts, but it would enable providers to meet the growing need, in particular, the tens of thousands of tenants who are going to be facing evictions as the moratorium expire. Filing fee surcharge revenue is an established and long-standing funding source for our civil legal aid delivery system. Senate Bill 530 would provide for Maryland Legal Services Corporation a much-needed infusion of additional funding. And for this reason, we urge you to issue a favorable report on Senate Bill 530. Thank you very much.
Excellent. Thank you very much. Good to see you. And next we'll move on to, likewise. Next we'll move on to Mr. Hepburn. You're up
Hi.
next.
Thanks for having me. My name is Peter Hepburn. I'm an assistant professor of sociology at Rutgers University at Newark and a research fellow at the Eviction Lab at Princeton University. I'm testifying today on behalf of myself and my colleagues Lillian Leung and Matthew Desmond in favor of SB 530. So I think it's important to recognize that America was in the midst of an affordable housing and eviction crisis that predates the COVID-19 pandemic. The rising cost of rental housing, coupled with stagnant wages, puts a growing share of renters at risk of eviction. In 2016, at a time of robust economic growth, we estimate that 3.7 million eviction cases were filed nationwide. That amounts to an eviction filing rate of 9.6%, or almost 10 evictions filed for every 100 renting households. In Maryland, as the Attorney General has laid out, these rates are far, far higher. In 2019, we estimated a statewide eviction filing rate of 92.5%, and those numbers are even higher in the state's most populous areas. I think at first glance, these numbers appear basically impossible. How can more than 100% of renters in Baltimore be on the verge of displacement in a given year? Simply put, eviction cases are not always a means of removing tenants. Rather, they're often filed repeatedly against the same tenants at the same addresses as a tool for property management and rent collection. Analyzing court records from across the country, we found that nearly 1/3 of households facing eviction in 2014 were filed against repeatedly at the same address. We don't, unfortunately, have case level eviction data in Maryland, so we can't estimate how common this is in your state. But these repeat filings are almost certainly underlying the observed high level of eviction filing in Maryland. These filings, what we call serial eviction filings, they bear very serious consequences. For tenants, having multiple eviction filings tarnishes their rental histories and creates barriers to finding housing in the future, even if they never receive a formal eviction judgment. Because landlords and property managers pass court and attorney costs on to tenants, serial eviction filings also increase housing costs. And these are increases that are falling to households that are already struggling to pay rent. We estimated that across the country, each eviction filing translates into a 20% increase in monthly housing costs for those who pay to stay in their units. Serial filings also increase burden on the civil courts. There was a 2015 report that estimated that rent court in Baltimore City processes roughly 1,000 cases a day. The report describes.
You could have a brief moment to conclude.
Okay. Overwhelmed dockets in Baltimore. Serial filing is only plausible in states where eviction filing fees are low and regulatory barriers are minimal. In such states, eviction courts function as the court of first, but not last resort. Maryland is unfortunately one of those states, and SB 530 would help to resolve that situation.
Excellent. Thank you, Mr. Hepburn. We don't have an actual visible clock here, so you get the voice of God telling you your time is up.
Very effective.
Our apologies for that.
Yeah.
All right. So next we'll move on to Mr. Hill. You're up.
Thank you, Mr. Chair, members of the committee. My name is Matt Hill. I'm an attorney at the Public Justice Center. On behalf of the 19 organizations and Renters United Maryland that are listed in my written testimony, we wish to urge the committee to issue a favorable report on this bill. For decades, the General Assembly has given landlords cheap, easy access to a state-subsidized debt collection process called rent court. This committee has the opportunity to end that special treatment today. By passing SB 530 and the other bills in the housing justice package, the General Assembly can change the court from one of front line of landlord debt collection to one of court of housing justice. I agree completely with the Attorney General on this matter. I don't want to repeat his testimony here. I understand you're also going to hear from someone who's experienced this kind of serial filing of eviction complaints and the way in which it piles fees on top of fees, 5% late fee, court costs, agent fees each month if the rent is late only one day. I want to emphasize the importance of retaining the strong protections in SB 530 from the court passing on the proposed surcharge to tenants facing eviction who can least afford it. If SB 530 passes, landlords will still be able to charge a 5% late fee. They'll still be able to pass through court costs, just not the additional surcharge that is intended to disincentivize the filing of an eviction action when the rent is only one day late. Landlords have invented a clever response that let's just leave this surcharge to judicial discretion. Let the court decide. That's what happens now, and tenants almost always lose. Default judgments in favor of the landlord, even when it's a significantly reduced amount of rent, the court almost always assesses those costs to the tenant. Even if the court does not assess those costs, landlords have lease provisions that allow them to pass those costs through to the tenant. Again, judicial discretion is code for the tenant pays. On behalf of the RUM members who are in our written testimony, we support this bill and we support the strong protections against pass-through. We do not need to pass through these charges to the tenants who are already struggling to face eviction. Thank you.
Excellent. Thank you, Mr. Hill. And next we'll hear from Ms. Brown.
Excuse the flashing on my screen. Can you hear me?
We can, yes.
Okay, thanks. I can't give details in the short time I have, but in the apartment where I rent in Greenbelt, starting mid-May 2018, managed by Ross, which is a huge company, I've been sued by the landlord for being late multiple times. The first time was January 2019. I'd started a new job and my check wasn't in the bank until the 6th. On the 6th, I called the leasing office and told them I had the rent, but I wouldn't get home from work until after they closed, so I would slide it under the door. A few weeks later, I got a lawsuit notice saying I was 2 months late. That happened again in January. I'm seeing people get evicted here with their belongings on the curb every month. My sliding doors face where their belongings go, and it's things like strollers and cribs. I figured they must be illegally evicting, and I was looking for a new apartment within months of moving here. Even without that stress, this building is raggedy. I don't have the time to tell you, but there are roaches, which I've never thought I'd ever live with. Water leaks in the hall. They have big buckets every time it rains, and I'm on the bottom floor, and this is an 8-story building, so it's going through the whole building. I've had 3 air conditioning leaks, one in my bedroom, one from the air conditioner above me, which caused my blinds to fall down. It made the drywall so soft that the blinds fell out of the ceiling, and one from next door. The one above me and next door leaked some kind of a chemical that burns your eyes, nose, and lungs. And the next door neighbor moved to a hotel. I couldn't afford to do that when her leak came under the wall and soaked my rug, and then she moved out. They took more than a week to fix it. I had to sleep in my bedroom with the door closed and the window open in the summer to be able to breathe. The day I went to find a less expensive, nicer apartment in Annapolis where I work was the same day that we had the COVID shutdown. So the day of my appointment, they called and they said they had to cancel my tour and that they couldn't rent to new tenants because of the COVID shutdown. So I had to sign another year in this place. The offices I work in closed due to COVID within weeks after that, and I had to go on unemployment. As a 1099, my unemployment is very little. What kept me going was the government help and help from my friends. Oh,
I know.
okay.
You can, sorry for that. You can have a brief moment to conclude that. Sorry.
Okay. My unemployment card with Bank of America gets closed. It's closed 4 times now, and it's always at the end of the month. When I'm about to pay my rent, I can't pay it. And at first they had the moratorium on doing anything about that, but when that expired, that happened, my card was closed, and it takes time to reopen it. It's just a confusion. Unemployment says it's Bank of America says it's unemployment. I got it reopened in short on December 8th. I called the office and said that I paid, and Kelly, the person who in the leasing office who processes payments and things, said, "Oh, I thought you were calling about the suit against you, asking why you were 2 months late again." And I said, "No, this is December and I'm paying December. I'm not 2 months late." And I didn't get she said there was an email. I didn't get the email. She then sent it after I'd already had my receipt and already paid. She sent me this email saying that I owed both December and January. And she said that's what the attorneys told her to do. The fact that she was saying everyone is calling her to ask why they're 2 months late tells you that she's not just doing this to me. I had more to say, but I'll stop there since I'm going over my time.
Okay, excellent. Thank you very much. So we'll entertain questions at the very end of both sides of the panel. So
I'll be here.
thank you very much. That'll conclude the testimony for the proponents of the bill, and I'll switch to the opposition panel. And we'll start off with Mr. Castilli. You are up. Bill, you there? All right, we'll move on to the next, and we'll come back to Mr. Castilli. Mr. Wiggins, you're up next.
Good afternoon, Mr. Chair and members of the committee. For the record, Grayson Wiggins with the Maryland Multi-Housing Association. The bill increases the surcharge fee 1,500% and removes the judge's ability to award fees with the stated purpose of deterring property owners from accessing the civil justice system. This exclusionary tax is unprecedented. Further, the Attorney General's discussion of the issue fails to consider a resident's right of redemption, commonly referred to as pay and stay, where a resident can pay their past due rent and fees in full at any time before the eviction and, by law, remain in the property. Per calendar year, a resident can exercise their right to pay and stay up to 4 times in Baltimore City and 3 times in the remainder of the state. Again, per calendar year. In Virginia, tenants are allowed only one opportunity to redeem their right to the property per tenancy. This is similar in our other contiguous states. So of course, Maryland has more filings when compared to these states. Tenants regularly exercise their right to pay and stay, which is why Maryland's actual eviction rate is below Virginia's and Delaware's and consistent with our other surrounding states. The inherent problem with this bill is that when filings decrease because housing providers wait to file, the tenants owe multiple months of rent, thus making the right to redemption that much harder to obtain. As a result, actual evictions will increase. Finally, asking the housing industry to absorb almost $70 million in additional business expenses annually will result in those expenses being passed on to all tenants. For the aforementioned reasons, we do respectfully request an unfavorable report, and I'm happy to answer any questions.
Excellent. Thank you, Mr. Wiggins. We'll now move on to Mr. Enton. I don't see Mr. Enton here, but I do see that Mr. Castilli's back up. So, Mr. Castilli, you're up.
Wait, I think I'm here. I didn't unmute.
There you are.
There I am. Thank you very much.
Snuck in there. There you go.
Robert Enton, thank you. Robert Enton on behalf of the Maryland Multi-Housing Association. This is totally, completely unprecedented in the state of Maryland and anywhere in the country. There is no Maryland law anywhere which says that a person who is owed money under a contract and has to go to court and file a suit to collect it can't recover the court costs if they prevail. No law anywhere. But this bill, unfortunately, singles out the landlord community in an unprecedented fashion. I'm not aware of any law in any other state which has a provision like this that applies to property owners. I've never heard of it. You're talking about a $70 million penalty imposed when the owners of rental property, and my guess is, what did they do wrong? Back in 1972, after a lengthy study, Maryland passed much of its current law. And what differentiates Maryland law is that we have what we call, the bites of the apple. 4 bites in Baltimore City, 3 bites everywhere else, which means a tenant can, let's say you got a 5-year lease, you can pay your rent once every 4 months for the entire 5 years, and the landlord can't do anything about it. The landlord has no remedy, unlike any other provider of goods or services. A landlord's sole remedy to quit providing the service of housing and the maintenance of everything else is to have the tenant leave the property. If I provide legal services and the client doesn't pay me, I don't have to keep providing legal services. If I sell them groceries or clothing or put, home improvements, whatever it is, and I don't get paid, I can stop providing it. But landlords can't. I would tell you that very, very clearly, while this percentage rate, I'm not sure what that is. I believe it's a percentage based on comparing the number of evictions to the number of rental units, but that's not a valid percentage. The valid percentage is what percentage of Maryland citizens rental citizens end up in being evicted. So the study that was referred to, this Princeton study, which comes from their eviction lab, was not a general kind of Princeton study. It comes from this lab. Okay, well, maybe I could get a question and keep talking. Could I make one point in closing, Mr. Chairman?
Very briefly, yes.
Okay, very briefly, just to say that this is totally, completely unprecedented, unwarranted, that we should not be able to recover these fees and that we should be penalized to the tune of $60 million. Thank you.
Thank you very much, Mr. Endon. Okay, next, we'll go back to Mr. Casilli. Good to see you. You're back up.
Thank you, Mr. Chair, members of the committee, Bill Castelli on behalf of the Maryland Realtors. And we recognize, obviously, the seriousness of the issues today for tenants and for landlords. We represent many property managers who represent a lot of single-family homeowners. You may have a owner that is transferring but would like to move back into Maryland, so they want to keep the property, and they when they move back to Maryland after their job has finished, after their job transfer is finished. So these are folks that might have 1 or 2 properties, and in some of our communities, in some of our rural communities, many of these small landlords make up a very significant portion of that rental population. And so while it's not just the fact that we're going from the $15 to $120, it's the fact that there's so many costs in terms of eviction right now, especially if you're a small landlord. Many of the counties right now require eviction crews. You might be spending, if you're going through eviction, it's not just the cost to file, and then another cost to actually exercise that. It's the cost that you spend to hire, possibly the 15 and 20 people that have to empty out the house, the locksmith, the truck that you might be required to have, or the tow truck in some counties. So there's a significant amount of cost that's already built into the process. And it does serve as a pretty significant disincentive for the smaller landlords. But this would just be another cost added on top of that. And when you're a small landlord and you're likely using a lot of that rent money to help pay that monthly mortgage, these add up quickly. And as other parties have mentioned with the 3 strikes out, this might not be the only time that year you face that situation. So we have concerns. We think a lower fee makes more sense and would encourage that. And for that reason, we encourage an unfavorable report.
Excellent. Thank you very much. We'll now move on to the final witness in the opposition panel, Ms. Howard.
Good afternoon. Can you hear me, Mr. Chair?
Yes, we can. Yes.
Very good. Great. Well, good afternoon, Mr. Chair, and the rest of the committee. My name is Kathy Howard. I'm general counsel for a real estate management company here in Baltimore City, Regional Management, Inc. We are a member of MMHA, and I am their legislative committee chair. I am here to sort of be the wrap-up hitter here on this topic. And I want to address two particular things. The concept of, quote, serial filings, end quote, and the idea that somehow landlords are getting have been getting special treatment from the legislature through the concept that of the real property code that has been legislated for over 40 years. Neither of those things are true. Serial filings is a myth because it is really tied to what is a very unique and very important right that tenants have to redeem their tenancy. You've heard a lot about that today, but I can't emphasize enough how important that is. And it was built into this system by this legislature as a balance to the right of the landlord to get his to collect rent through a system where a judge was the arbiter of the situation and made decisions based on the facts. And the second thing is that we are not getting special treatment from either the legislature or the courts, and it is I think it is somewhat disingenuous to suggest that we are. This is the only way that we can collect rent legally. That's how the legislature wanted it, and the balance between the right to redeem and the landlord's right to collect his or her rent has been a cornerstone of the landlord-tenant law in this state for over 40 years, and I would submit to you should not be changed.
Okay, thank you very much, Ms. Howard. That'll conclude the testimony for Senate Bill 530. We'll now turn it over to the committee for questions. I saw Senator Heddleman first, then Senator Lee, then West, then Sidnor. So Senator Heddleman, you're up.
Thank you very much, Mr. Chairman. I guess I have a question I think I'll start with Mr. Hepburn, please. You spoke about your examination of Maryland, and you obviously, as a researcher nationally, have a much broader perspective. And we saw the data that the Attorney General presented with regard to the comparison between our state and other states with regard to eviction filings. And, we're talking 80-some% and then single digits in other states. And you spoke about the detrimental effect that serial eviction filings have with regard to agent fees, court costs, other things. We just heard from the opposition panel that, well, people have a chance to redeem, right, 3 times before they would actually become evicted, and which, in my opinion, kind of glossed over the deleterious effects that even those filings can have on a tenant. Can you expand on that a little bit? I think you got cut off in your time. And it's not just if you could talk about how that affects them later. It's not being necessarily put out on the street, which is horrendous in itself, but the actual court filing. And then if you could also just talk about Maryland, it appears to be is different from other states in how we handle this. And if you could just shed a little light on what you see in addition to this fee differential, if there are other things that you see that contribute to, the drastic the differential in terms of filings.
Absolutely. Thank you for the question. So to your first point, we have good evidence, and there's been a great deal of reporting and investigative work exploring the effects of eviction filings on tenants' ability to find housing in the future. So we know that people who have been filed against for eviction, even those who are never evicted from their units, will have a harder time in finding housing in the future. So what this tends to mean is that they, instead of being able to find housing in a similar neighborhood, they're being forced to move to higher poverty, higher crime neighborhoods where the landlords are less restrictive about who they're willing to rent to. And when you have been filed against multiple times, the set of options that are available to you becomes increasingly poor. And as we heard in Ms. Brown's testimony, there clearly are the bottom end of this rental market can be quite difficult. To your other question about whether Maryland is appreciably different than other states, I think when we look nationwide at eviction filing rates, Maryland is very clearly a significant outlier. The eviction filing rates that we see in Maryland are extremely unusual and really can only be explained by serial eviction filings. While I disagree, I would not disagree with Ms. Howard's contention that these serial eviction filings are a result of legal and regulatory structures in the state. And I think that the provisions of this bill would help to dismantle the legal structures that encourage landlords to use the courts in this fashion.
So we've heard from the opponent, if I could have a follow-up, Mr. Chairman. We've heard from the opponents that it's their only way to collect rent, right?
Yeah.
And so I assume that's the case in Virginia, Wisconsin, Minnesota, wherever. What is it that they're doing that we're not doing, that where our landlords feel like their only recourse is to go to court?
Thank you. So what we found is that, so we conducted interviews with landlords in a number of states, including states where the filing fee is significantly higher than the $120 that is being proposed here. We conducted interviews in Mobile, Alabama, where the filing fee is $275. And what we found there is that landlords, they're still collecting rent. That's going to mean a lot more outreach to tenants, a lot more knocking on doors, a lot more phone calls to their tenants, but we didn't find any appreciable evidence that their bottom line was affected by this higher filing fee. So they weren't using the courts to collect the rent, but they're still able to collect rent. And now, when the opponents to this bill mentioned this $70 million increase in payments that they would have to make, that's assuming that they continue to file at the same rate. If they were to simply reduce their filing rate, the financial impact of this bill would, of course, be much, much smaller.
So it does seem to, from what you just said, what I just heard is that landlords elsewhere outside of Maryland are finding other ways of collecting rent without necessarily affecting their bottom line.
Absolutely.
Being a little more creative. And thank you very much. Thank you, Mr. Chairman.
Thank you very much, Senator Hettleman. All right, next we'll go on to Senator Lee. You're up.
Thank you, Mr. Chairman. I just wanted to be able to address some of the arguments that have advanced by some of the opponents, but I'd like the Attorney General to respond to some of them. Are most of the filings actually done by larger landlords, and it's a percentage a lot higher, especially partaking in these low filing fees? And maybe you can address what Bob Enden said about unprecedented and also the serial filings being a myth, because I think that these arguments need to be addressed. I don't think they were adequately done enough time to.
Yeah, well, thank you very much for the question, Senator. Serial filings are not a myth. You don't have 92.5% of the units filed against in Maryland in any given year. You have that number of filings, but they're going against the same units time after time after time. And as I said, we have been involved with landlords in litigation and have found situations in the case of one very large one where they file every month on the 6th. So if you haven't paid by the 6th, you're in court already. And as Professor Hepburn said, the way that's handled in other states is the landlord gives you a phone call and says, hey, I got to have your check. If you don't get me your check right away, then we'll file suit. There are many states, and I believe Senator Sidner has a bill that would do this. There are many states that require notice to the tenant that the rent has not been paid, it's overdue, and that the landlord intends to file suit. That also diminishes the number of serial filings. The idea that this is somehow a $60 or $70 million penalty is absurd. It's standing the situation on its head. Number one, as Professor Hepburn said, it probably won't be that much money. But number two, what it shows you is how cheap it's been for landlords for so many years. For decades, Maryland has not even covered its costs when charging filing fees, but have created this perverse incentive where the landlords now use our district court as its collection agency. And I would say also, the provision that prohibits the landlord from passing this on is not unprecedented. It's in fact the rule with respect to attorney's fees. It's the American rule is that each side pays its own unless there's an agreement to the contrary. In Maryland, we prohibit in a number of different situations provisions in contracts that are adverse to consumers. Lenders can't pass on inspection fees and things like that. And it's not unprecedented in Maryland. It's not unprecedented anywhere else in the country. But here, when you have a problem that is pronounced and obvious as it is, a 92.5% filing rate, something needs to change. And taking Maryland up to around the national average is not unfair to landlords. As Professor Hepburn said a few minutes ago, there are landlords making a living all over the country, and having them pay a reasonable cost and not putting it off on the tenant who are under severe economic stress when they're about to lose their home. It does cost landlords a bit more to carry out an eviction. They've got to hire the folks to remove the property, et cetera. But for the tenant, it's everything they own. I mean, it's their entire property. So the balance of hardships, if people are complaining about the hardship that this imposes, contrast it with the hardship that the tenants undergo.
Okay, thank you, Mr. Attorney General.
Excellent. Thank you very much. All right. Now we'll move on to Senator Sidnor and then Senator West.
Thank you, Mr. Chair. I just had one question. During Ms. Howard's testimony, she had talked about, I guess someone must have made some statement about special preferences or something. And I'm curious if any of our witnesses, whether it be the proponents or opponent, would mind sharing with me the history of the ability for landlords to have non-attorneys actually speak at court, which I think is it's a benefit that no other non-person party is able to do. Can you explain how that came about? Because I'm assuming that probably saves on a lot of cost and things for the industry. Ms. Howard, it looks like if you wouldn't mind, if you could share.
So Senator, how do you want Ms. Howard to respond?
Yeah, I think she was shaking her head, so I'm assuming she should. Thank you.
A lot of eager. All right.
Sure. Thank you, Senator Sidnor. I'd be happy to give you a little background and a little history. The rent court statute, or the failure to pay rent statute, was a part of a larger commission, landlord-tenant commission study, and then legislation that came from that, both in 1972, I believe it was, and then later on, about 20 years ago, there was a revision of all of that with a large study as well. You're specifically asking about the concept of an agent as opposed to a lawyer representing the landlord in landlord-tenant court. The concept that the legislature put together in this situation was supposed to be a very inexpensive to both sides, product or procedure rather, and also one where there would not be the necessity for a person to feel that they had to have an attorney in order to appear in court. And that went for both the tenant and the landlord. The idea here was so that there would be a dialogue in front of a judge who could make a determination with very, and it would be a very limited question that was being presented. Essentially, was there unpaid rent, and was there any reason that the rent went unpaid? That's why you have the ability of the tenant to bring up whether or not there is a rent escrow issue, both as a defense to a rent action and also as an affirmative case of their own. So it's designed so that neither party has the necessity for having legal representation. They can go in, talk directly to the judge themselves.
Thank you very much.
And that's why the agent program, that the agent's idea happened, because a lot of time the owner of the property hires an agent or a management company, if you will, to do the work for them. And that's where the agent concept came from.
I appreciate it. Thank you, Mr. Chair.
Excellent. All right, thank you very much. All right, now, usually the senator asks for the witness, so I just want to. All right, so Senator West, you're up.
Thank you, Mr. Chair. So I admit being of mixed views on this. Ms. Ehrlichman in particular will recall that about 10 or 12 years ago, when I was on the board of the State Bar Association, on the Board of Governors, we all met in the Senate chamber for one of our meetings, and you were supporting a bill to increase the charge on filing fees by a couple of bucks a piece. And I stood there and strongly supported that motion. And the president of the Bar Association at the time basically called me out and told me to sit down. And in no uncertain terms said, maybe you support such an increase, but other lawyers do not. Well, eventually we got that done. But the difference between then and now is that increase was a couple dollars per filing, and it covered all the filings in the state. This increase is a 1,500% increase, and it only covers a very small number of filings. Well, filings by a very small number of plaintiffs, only the landlord community. Not everybody else is filing pleadings or cases in the state. So I sat there trying to figure what I would do if I were hit with these high filing fees, if I were a landlord. So Ms. Howard, could I talk to you for a moment and ask you some questions? So if you would unmute Ms. Howard. The reason I chose her is she is a former president of the Bar Association, but she was not the president on the dais that evening who called me out and made me sit down. But she can answer these from the landlord's perspective. And so I wondered, if I were a landlord and were hit by this much higher filing fee, what would I do? So here's my first question. One thing I might do is not file as frequently, is only let the rent mount up for a couple of months and then file. But then, Ms. Howard, is that something that landlords would consider doing? And if they were to do that, isn't it likely that that would result in more evictions because the tenants wouldn't be able to pay 2 or 3 or 4 months worth of rent at a time?
Thank you, Senator West, and I fear you are correct. That it stands to reason that if tenants are not paying their rent month after month, that it is highly likely that that you're going to do, if it is this filing fee at this size goes through, you are going to bide your time and file multiple months at the same time in order to cut those costs. There's also another unintended consequence, I think, of this surcharge not being able to be recouped by the landlord, and that is that if this is a very large expense, and if you're the landlord, you're going to spread that expense not just on the non-paying tenants, but your entire tenant base is going to be affected in the form of increased rents, because you've got to make that expense up somehow.
Well, that was going to be actually my next question. So is it also possible that facing these increased expenses and increased delinquencies, because people won't be paying for months at a stretch until you finally take them to court, that the landlords will see that they have to recover that money some way? And one way they might do it would be through increased rents spread out over all the tenants.
Yes, and that is, I would submit to you that is terribly unfair to those tenants who are well paying and doing exactly what they're supposed to be doing under their leases. However, those expenses to the landlords, there are some, there may be some absorption that can be done, but at the size of the surcharge increase that this bill is talking about, I don't see that is going to be possible on a long-term basis.
So continuing along this line, another thing I thought I might do if I were a landlord would be to increase the amount of the required security deposits. Is that something that landlords would be able to do, or would be likely to do, or both?
Well, I think that you have to keep in mind with that question that under Maryland law, there is a finite amount of money that a landlord can ask in security deposit. It's twice the cap is at 2 months, the equivalent of 2 months rent for a security deposit.
So if a landlord currently took 1 month, the landlord could increase it and take 2 months.
Yes.
You're currently taking 2 months, you couldn't increase security deposits.
That's correct.
Okay, let me go to the next one. What about more thorough background checks? If I were a landlord faced with this kind of a fee, if the tenant didn't pay the rent, I think I'd be more likely to want to rent to tenants who would be able to pay and didn't have a past history of rental delinquencies. Wouldn't I be more likely, or maybe not, to do more thorough background checks, which would exclude some tenants from being able to get to find rental housing in those situations where the more thorough background checks are conducted?
That is, I would say that's certainly a very, very potential unintended consequence of this piece of legislation. You're exactly right. You're going to want to find a tenant whose rental payment history, assuming that you can gather that information from other landlords or through some of the court filing systems, which are not all available in all jurisdictions at the moment, that you are going to look for that and to try to make your risk less. And again, the other unintended consequence of that is that you are certainly going to make it tougher for people who are already having a tough time to find rental property. And I think that is just not something that the advocacy community is trying to do with this, but I think that's an unintended consequence that will happen.
And then lastly, especially I would think if I were a landlord with only a couple of properties, not one like yours, you've got a lot of property, your organization has a lot of properties, but many landlords just have a few properties to try to supplement their income. If I had to pay these fees, one thing I might do is stint on the maintenance of the properties so that I still would have the same amount of income coming in. And so long term, of course, the long-term disadvantage of that is the properties become more and more run down. Do you think it's likely that the smaller landlords might do that?
Well, I think two things. I'm a little bit of two minds on that one. I think that it's going to be that might be very much a temptation to try to cut your costs on that side of your ledger, if you will. However,
there's a downside to that.
There is a huge downside to that, because that is not only it is making your rental property less valuable, but it is also exposing you to more litigation with your tenant because of the rent escrow procedures and code enforcement things. And we have licensing statutes all over the state of Maryland that basically say you have to have a certain you have to meet the codes. And if you don't meet the codes, you do not get your license. If you don't get your license, you can't rent. And it is really not a good idea. And frankly, even for a small landlord, that expense is going to have to be paid. And unfortunately, if you can't get the rent, there is very little that you can do other than to bear that expense. And that is not a good thing either way around. You're just going to wind up raising your rent.
Thank you, Ms. Howard. Now, if I could, Mr. Chair, before I finish, if I could turn to the Attorney General, who's heard this litany of possible collateral consequences as a result of this bill, and give him the opportunity to respond and indicate whether or not he thinks some of these collateral consequences are fictitious or that some of them could indeed materialize.
Senator, first of all, thank you very much for the question and the opportunity to respond. You know, there's an old saying that even a dog knows the difference of being stumbled over and being kicked. And what I would say to you is, don't fool yourself that you're doing tenants a favor by having a $15 filing fee and having 660 to 700,000 cases filed every year with only 739,000 units. It's created an economic situation in which it is to the landlord's advantage to file suit every month. It's free, essentially. So they file suit every month, and they use our courts as their collection agency. In stark contrast, elsewhere around the country, where the fees are significantly higher. I mean, we're at the very bottom of the list. This is not a penalty. They've been getting away with the deal of the century for decades. And so, you know, it does not redound to the tenant's benefit to have somebody in court on the 6th. What I predict, if you pass the bill as is, what I predict would happen is you'd have landlords doing what they do in other states, which is they call the tenant up on the 6th or the 7th and say, hey man, you know, I don't have your check. You give tenants like Ms. Brown the opportunity to say, look, I slid it under the door last night. Instead, you know, the landlord's already in court by the time she pays her rent on the 6th. And now she's got to pay a 5% late fee. She's got to pay a 5% late fee on the 6th anyhow, but now she's got to pay a lot of other costs and show up in court to make sure that the amount of the judgment that the landlord gets is what she really owes, as opposed to what her landlord is claiming, which is that she owes 2 months rent.
Would it make sense to consider either eliminating or reducing the number of redemptions that are possible per year?
I don't see why that's relevant. I mean, when there is a redemption, the landlord is made whole. Not only are they made whole, they get 60% interest on their rent. We allow in the state of Maryland a 5% late fee. So when the rent is unpaid, the landlord or is late, the landlord makes 60% a year. That's a hell of a rate of return. And in order to redeem, you've got to pay every nickel. You've got to pay the attorney's fees. You got to pay the agent fees. And right now you have to pay the entire court costs. And let me just give you a contrast between Maryland and the District of Columbia, because in DC, the tenant also has the right to redeem. But in DC, and this is information that I got from the Public Justice Center, in DC, the filing rate against cost burden households, which is, I think, a census driven number, is 0.54 cases, 0.54 In Maryland, it's nearly 5 times higher than that. It's 2.35 cases per cost burden household. So DC, which has a filing fee which is the same as ours right now, about to go to $100, we believe, has a fifth of the filings against the poorest tenants, and they have the same right to redeem that our tenants do in Maryland.
Thank you all, Ms. Howard and the Attorney General, for your answers to my questions.
Thank you, Senator.
So thank you, Senator West. Thank you, Attorney General. So we'll go see Senator Castley. You moving around my screen. Here you go. You're up next.
Thank you, Mr. Chairman. Since the Attorney General is unmuted, oh, you just muted him.
Oh, sorry. There we go. Got him. Hold on.
I was just going to follow up on that.
Committee. I mean, after the week we've had, this is amazing to watch. So.
So, hi, Mr. Attorney General. Good to see you, sir.
Good to see you, Senator.
For visiting us this way. So I'm really curious because what you just said, that I'm going to restate it. You tell me if I've written this down wrong. The DC with the same filing fee, court filing fee, has only 1/5 of the filing against the poorest tenants that we have in Maryland. So why? What's the? How do we explain that one? I think that's really important to understand.
Yeah, the reason is they require more notice to the tenant before the landlord can go into court. They're about to raise their fees to the range that we're talking about, $100.
Yeah, but before the fees are raised, I'm just trying to understand that I mean, we're saying it's the fees will fix it, but they have 1/5 and they haven't even raised the fees yet. And so for them, can you just expand upon that? Just, I mean, I don't want to. I realize you're the Attorney General and landlord-tenant isn't. You're not a landlord-tenant lawyer, so feel free to push me off to somebody else. But in that, do we have a sense of what are the things that DC is doing that you think are making a difference?
I think that Matt Hill can give you a more detailed description than I can of what's going on in DC. But my understanding is that they require notice to the tenant before the landlord can file an action. And I'm not sure what other requirements they have, but they don't have the same rate of serial filings that we do. We have 90%, they have around 15%, I believe. So it's 6 times as much. And one way of addressing that is certainly to increase the cost. And coincidentally, the cost in Maryland hasn't been increased for a long, long time. And it's at a rate that really pertains to a time decades ago. I mean, when you file a lawsuit, what happens to those pieces of paper? The court has a whole bunch of different people who put their hands on it, look at it, stamp it, approve it, send it on. $15 doesn't cover the cost for our judiciary. They're not in here asking for the cost to be raised because of that, because the money doesn't go to them. It goes to the general fund unless we direct it somewhere else. But what I'm saying is, we have a confluence of conditions that have caused this sky-high serial filing rate. And one of them is the cost, and others are notice.
Thank you. If I could ask Ms. Howard some questions, please, Mr. Chairman. Hi, Ms. Howard. Thanks for being here. Look, so this is I would consider this a pretty heavily regulated industry with a long history. And so I've only been in this body for 7 years now, and I appreciate that there was a lot of smart people here before me and for decades and decades. And so I'm always hesitant to, I don't want to overlook how did we get here? Because I have to assume that these laws that we have on the books now were put there by smart people who were not trying to screw the tenants or screw the landlords, and we're trying to do the right thing. And you gave a bit of the history, but what you said was that so I understand the theory you said was that we would have at this time, this was back in, I guess, 72 and again in around 2000, that what we were looking for was a framework where we would have a low cost forum in which landlords and tenants would meet in front of this judge and move this forward. Why were they there? I mean, what was the system before that we were erasing, and how did we get here?
Well, thank you, Senator Cassidy. I think that one of the things I neglected in my in doing my history lesson was to note that the concept, what we had before then was simply self-help eviction. And the landlord, I've heard a lot today about how in other places it must be that the landlord, if they have such filing fees or they can't file very often, that they should just go up and call their tenant, tell them that they haven't paid, knock on their doors and ask them nicely for the rent and all that kind of stuff. But unfortunately, the real facts of the matter were back when these commissions were looking at the balance between landlords and tenants. There was a lot of intimidation and a lot of harassment, or at least there were claims of that by tenants whose landlords did not, who knocked on their doors to get the rent, and were not. It was not necessarily a very pretty situation. And what the framers of this law tried to do was to balance the need to get the rent for the landlord against the idea that there should not be intimidation and there should not be a situation where the landlord intimidated his tenant into paying. And there were a lot of horror stories that got told during that period of time. People taking off doors and until the tenant paid the rent, and just some awful, awful practices. Now, I'm not saying that would happen again the minute that this type of bill would be passed, but I do think that there is we're trying to establish a balance here, and we're trying to make sure that it's a fair process to both the landlord who needs to get his rent to pay his expenses, and also to have a tenant have a forum where they can bring problems that they may be having with the unit to the attention of a judge who is an unbiased arbiter, and have their disputes, whether it be over unpaid rent or undone repairs, in a courtroom where there is someone who can sift through all of those facts and make a decision. This is not just a collection court. This is where you go to, if you're a landlord and a tenant and you don't have to be represented, and you make sure that this procedure works the way it's supposed to, in a balance. And then eventually everyone's interests are taken care of by the judge.
I mean, I having sat in different district courts from different matters, I can agree with you that the atmosphere in landlord-tenant courtroom is much different than your average, motor tort courtroom, speeding ticket courtroom. That it's more of a bazaar of people cutting deals and figuring out what's what, and so it's more of a controlled forum, and the cases move really quickly. But let me ask you this: so we hear serial filer, and of course the reciprocal of serial filer means a serial late payer, right? I mean, landlords not filing against people who aren't paying. Do we know what percentage of? I'm not sure if the Attorney General's slides show this. I don't recall, but do we know what percentage of these filings are against serial late payers? I guess for lack of other words.
I think that I know that there have been some, that some of our other panelists have checked on that. I believe that there are some there. I've heard some, I don't know myself what those statistics are, but I have heard that there are somewhere in the range of 60 to 80% of those quote unquote serial filings are against folks who are paying late time after time, month after month after month, the same people. And
I mean, one would think that they
why
didn't.
that is, I don't know.
One would think that they wouldn't require a monthly knock on the door, that especially if they've been sued a few times. What do you have a sense of why the folks that aren't paying? Do you have any idea of what the reason? Why are they not paying?
It can be if the chronic person who is chronically late.
Yes.
Often is balancing his or her priorities. And the unfortunate thing is that the priority does not appear to be rent. That's the only thing that I can say. What other priorities they have that are more important than rent, I have no idea, but it is an unfortunate fact of life that some people do not consider it a priority.
Yeah, I mean, I would hope that it's not maybe Maryland's social safety net for people who are hard up for rent money is inadequate or something, and so we end up. Can you speak, or one of the other panelists, on what is the adequate, as far as the marketplace for private tenants, leaseholds for middle to lower income in Maryland? Is it plentiful, inadequate? Where do we stand on providing an adequate stock of private leaseholds for particularly those in the middle to lower incomes?
I can only speak to my own experience. Regional Management is a company that has very affordable middle to lower income and market rate housing, mostly garden apartments in Baltimore City and Baltimore County, some rental townhouses. And we built it as affordable housing, and we continue to operate it as affordable housing. We have all kinds of folks who work at Amazon and Hopkins and our police officers and firefighters also. So it is workforce housing, and those folks do try to make it a priority that they pay their rent. But unfortunately, there are some people who simply.
I got it. Well, maybe there's another panelist. If there's anybody, they can just raise their hand. I'm just my question is, maybe Mr. Anton raised his hand down there, or Mr. Castelli. Which one? If you can tell us what. Can you just undo Mr. Castelli there, and we'll try him.
Sure, we're going to do Mr. Castelli and then the Attorney General.
Okay.
Okay. So good.
And my question is really as to the availability of quality. I don't want clap fire traps, but the availability in the market for low income private rental housing. We know that Maryland's been notoriously derelict, or not derelict. We've had terrible experiences with public housing for the low income people. It's been a horrible thing, and thank God we've diamondated a lot of it. So we've already committed ourselves to the private market, and I'm just wondering if the current system is providing that housing, the housing market needs.
I would say, Senator, that the housing needs assessment that was recently issued by the Department of Housing and Community Development did address some of this. Mm-hmm. They estimated about 80,000 units in deficit of families and households that are about 30% of AMI. And that's pretty consistent with what we see. Freddie Mac did a study last year, released it, I think, in the spring, just after the shutdown, where they estimated Maryland's at the 11th highest housing deficit in the country. That includes both, for sale housing as well as rental housing too.
So we're 11th on the 50 states. Is that what you're saying?
Correct.
So we're better than 40 than 50. I'm sorry.
Well, we're higher. We have a higher housing deficit than 11. So right, 39 states, other states. So we are at the high end of our housing deficit.
Okay, so we're number 11 from the top of
right.
being bad, and not number 11 from the bottom, right? I mean, let me give the Attorney General, let's give the Attorney General, I know he's go ahead.
Senator, I agree with Mr. Castelli on this. There's an acute shortage of affordable housing in Maryland. And unfortunately, that shortage and the ease of getting into court puts tenants at a huge disadvantage. And what it means is that tenants like Ms. Brown and a number that we've seen in the actions that our office has brought suffer with chronic leaks, rats, mice, rodents, roaches, etc., mold. And so they're living in miserable conditions, and there isn't very often, and there aren't affordable choices outside the ones that they're already in.
So I guess it just seems to me that our primary goal here, this is sort of a side goal is what we're pursuing, but the primary objective ought to be encouraging an adequate stock of housing available. And I'm just wondering how this particular bill feeds into that, because doing that seems to me it necessitates that Maryland is a good marketplace for these corporations that would invest in the land in the rental market industry. And we wouldn't want to do things that would say, oh, that's Maryland's a bad risk for the rental market. That's going to set us back. We'll end up number 5 from the top of the bad boy list if we don't be careful, right? I mean, okay.
If you're asking me that question, Senator, I mean, this bill would bring us to about the national average. And I don't think that's too much to ask of the market. I mean, it's proved in most of the rest of the states around the country that this is a cost that's reasonable, and that this is an approach that's reasonable.
What we have to, what we've heard, what I've heard from the testimony so far is it's when we look at the national average issues, we got to factor in these other characteristics, such as do they have limits on the amount of security deposits? Do they allow right of redemptions and right of redemptions up to 4 times? So all those things come together to make you, seems to me, what are that was just 3 of them, but I don't know what that full bundle of issues are that would make a state either less desirable or more desirable to the private markets. And I think that's what we really have to be careful of here is making sure that we offer a competitive market to attract these developers in to build the houses, right?
I think it's yes, and this bill it doesn't purport to do everything.
No, I just don't want it to undo stuff. I realize it's not going to be a fix-all, but I don't want it to be a destroy-all either.
Yeah, I mean, I disagree with the proposition that somehow the right of redemption impacts on this, because as I said before, landlord becomes whole when the tenant redeems, and it's a pain, but not only are they made whole, they get 60% interest on their money.
Yeah, but it does mean that I can't get rid of, if I have a tenant who's an egregious no filer, who I don't want them. I mean, I want a tenant that's going to pay every month, but if I have a tenant that's going to egregious no pay, they can sucker me along for a year. I'm going to have, if I had my druthers as a landlord, you're out of here. I'll give you twice on that and you're gone. But in Maryland, as we've heard, you can do the right of redemption 4 times in Baltimore. So based upon the amount of months it takes you to get to the point where you can enforce a right of redemption, you've got about a year going by between the filings it takes and the file to get the warrant of eviction and all that. So now you've covered a full month. And if a perfect landlord saying, I can solve this problem after the second time you do this, you're out of here. But Maryland says, no, you're gonna have to keep filing and filing and filing. So what I don't have a good sense of is how much is our eviction filing rates inflated by the fact that we have this increased right of redemption?
I don't think they are. I mean, the landlord is made whole every time the tenant redeems.
No, I got it, but he's got to file. He's still got to file. The landlord has to file.
Yes.
Keep on filing.
And landlord's made whole and earn 60% interest. So right. It's not a terrible deal. And I just don't believe that the right of redemption is what causes the problem. There, we have a serial filing rate that is unlike that of, I don't know if we're at the top, but at the very top, but we're up there. The national average is 6%. We're either a huge outlier or there are one or two other folks that are in the same boat as we are.
All right, thank you, Mr. Chairman. I appreciate your patience. If I could, just a few questions for Mr. Enton, and then I'll be done.
Sure, of course.
Okay. Hi, Mr. Enton. Good to see you.
Hi.
Do you know, first of all, on the issue we're just discussing, I mean, I'm a believer in the marketplace, and I want to, it just seems to me that we're not doing well, from what everybody agrees, on the availability of low-cost rental housing, quality low-cost rental housing. And I'm a believer that we solve that by making our state competitive for low-cost rental housing investors. And you've heard some of the responses to that. Do you have any thoughts on those issues?
I do. Thank you. I've represented landlords before the Maryland General Assembly since 1983. That's a hell of a long time. And I've seen a lot of things, come and go, and a lot of things change. I wasn't here in 1972, but I was here the last time they updated this. And, there's just no question that it's, the market has changed. You have a kind of a balance between larger corporations that own several hundred, maybe 1,000 properties, and small landlords that maybe own 3 or 4. But I'm not aware of any other state in the country that allows a tenant to default on their rent 3 or 4 times in a year and stay in the property. My understanding is, in talking to people that were here back in 1972, is that the $15 charge was put in place so that when the tenant redeems, and I would tell you that 90% of all tenants, before the sheriff shows up with a writ of restitution, pay it current. 90%. That was so that rather than having to pay $30 or $40 or $50, they only have to pay $15. So in Maryland, where the filing fee is $15, the warrant of restitution is $40. And so that puts us in line with all of our surrounding states. West Virginia is 50 to 70, Virginia is 50 to 70, Delaware is 85. But the idea of the 15 is, look, if you pay that rent before the sheriff shows up with the warrant of restitution, all you have to pay is $15. That's it. And I think that it is a tough market. We've got the lead paint laws. We have a very robust, set of landlord tenant laws that every single year, retaliatory evictions and this and that, over all these years. And it's not an easy business. And if you don't think for 1 second that increasing the cost to landlords statewide by $60 million is going to have a negative impact on affordability for tenants, I don't know why you think that wouldn't be passed on. And the difference is, if I'm a regional or national corporation and I want to build an apartment house, or I want to build an affordable housing property, and I'm looking at this state laws and that state laws, I'm looking at Virginia versus us, I'm looking at Delaware versus us, and what am I going to do? Where am I going to invest my money? Am I going to invest it in a state where it's going to cost me $120? And unlike any other state that I know of in the country, I don't know, while I know the Attorney General has indicated that other states have filing fees on the average of $112. I didn't see that statistic when I read the Princeton eviction report, but I take his word for that, of course. Unlike any other state, we would be the only state that I know of that prohibits a landlord from recovering the court cost in a case. I don't, just as a blanket prohibition, regardless of the facts, regardless of the circumstances. I just don't see that. When I look at the other states, I think I'm aware of one. In Virginia, you get one bite of the apple, but you don't get that bite if a judgment's entered at all. You're done. So I think it would put us in a very, very uncompetitive state. And I would point out that if the tenant can pay the rent, there are no evictions. The state of Maryland is going to get $402 million in rental assistance for people. If we need to completely revise the landlord-tenant laws, we should do what we did in '72, and we should do what we did 20 years ago. Let's get a group together and go through it. But this just seems to be, a really bad time to do this and not justified by what goes on in other states. And I'm very, very much concerned that while I saw dozens of landlords go out of business, families that own rental properties for decades, so my clients were 30 years ago were like me. They were in their 40s, and their parents had retired, and they had passed their rental properties on to them. Every one of them is out of the business now. So I think it's a precarious thing to do, Senator.
Thank you. Appreciate it. Thank you, Mr. Chairman. Appreciate it.
All right, thank you, Senator Kessler. All right, we've been burning this candle for a little over an hour here, so we'll go on to Senator Hebbelman and then Senator Sidnor. But we're crunching up.
Thank you very much, Mr. Chairman. I'd like to ask Matt Hill if he could respond to some of the issues that have been raised, especially with regard to our neighbor in DC, and that other states are, and I think what Senator Castley said is important to look at, that other states have other housing policies that contribute and enable their landlords to collect rent in a different sort of way rather than using a filing. So if you could speak to that a bit, I'd appreciate
it. Sure. Thank you, Senator. So with respect to DC, so the point that we're trying to make is that landlord has an incredibly cheap, easy access to this rent court collection process. And someone said that I was being disingenuous when I said that, and I'm not. There is no other type of case in Maryland where you can get a trial 7 days after you file a complaint, usually with 2 or 3 days notice to the tenant. We're also talking about a no discovery process. The landlord agent representation is a very unique benefit to Sidner's point. And what it resulted in, regardless of what the intent was, is that 96% of landlords are represented in these matters, not always by attorneys, often by attorneys, but by special agents who are there every day at rent court and who know the rules and know how to move through the process to their benefit. So I want to just clarify that. I also want to say that to your point about DC, so one of the ways DC reduces filings, and this is what we see across the country, is that they require the landlord to provide a notice to pay, right? Excuse me, the landlord has to provide a notice to the tenant to pay or quit. And so what we see is, there's a 10-day notice to pay or quit. DC does this, and I think it's more than 10 days. I'll have to go back and look. But that, if you don't pay, then we can file a failure to pay rent complaint. But you don't just have this filing on the 6th of the month every month. I think that's really important. So no matter how you do it, whether you take the DC approach or another approach, DC also, they're investing $5 million a year toward a right to counsel in that jurisdiction. It's not quite right to counsel, but it's getting close. And so that's another disincentive for the landlord to file a frivolous complaint. What we see in Maryland, I have to look at the exact number. I was trying to file it, but I find it, and I was also trying to pay attention. Not most, but a good percentage of these landlord failure to pay rent complaints are dismissed, right, prior to or at trial. Why? Because the tenant was only a couple days late. So by the time you get to trial a week later, case is gone. I think it's close to 30%. I want to check that math and I'll get back to the committee. But many of these complaints are dismissed either prior to trial or at trial because the tenant's already paid. Why? Because we're allowing landlords to essentially use the rent complaint process as the first somebody on the rent. Why don't tenants pay? There's all sorts of reasons. One, often they don't know that they're behind on the rent. Landlords add in repair charges. They add in all these different fees. I have a lot of clients who think that they're up to date on the rent, and then they come to find out they have a rent complaint. Why? Because landlords have added these additional fees and repair charges to the balance. Some of them are withholding the rent because of significant conditions issues on the property that threaten their life, health, and safety. There are numerous reasons some of the landlords are not licensed. There are numerous reasons why a tenant may be withholding the rent or may be behind. And so I agree that there is a lack of affordable housing. To Senator Cassidy's point, the General Assembly should do both, and it's investing in the production of new affordable units. But at the same time we're doing that, we can also make it a little bit more difficult to evict someone, give tenants a few more rights in the process that is heavily skewed toward landlords.
Thank you.
I could go on.
So thank you, Mr. Hill. Thank you, Senator Hettleman. Senator Sidnor, are you good to go, or do you have a question? Okay, great. Excellent. Looking around the room for additional questions. All right. So with that, that will conclude the hearing. Ms. Brown, sorry. You had something, was it responsive to a question you had?
You aren't really talking about people like me. As I was working on this, I discovered that even though I didn't get the paperwork in the mail like I did the 2 times, they filed suit against me multiple times. I didn't get the paperwork and I wasn't late. And the 2 times that I did get the paperwork, I was a day late. You need to address that person. That can't be right. I've never missed a month. Never. And yet they filed and filed and filed.
How many times were you
You
actually
have it in
served?
your paperwork. You have it in your paperwork. I've been served twice. For the 2 times that I actually was a day late, January and March of 2019, I was served the papers. The other times, we found out as I was talking to one of your members of the committee about testifying, he said, oh no, you've been sued this many times, and sent it to me. And I wasn't late those times. And what the person in the leasing office does is when I pay, right now she's holding my check even though she has it. When I pay it, she doesn't process the check. So there is some reward for them to hold my check and file suit. And then they know they're getting paid. They've never not been paid. Why are they rewarded for that? Somehow they are, or they wouldn't be doing that to me. You're not addressing that. That needs to stop.
Thank you for that. I appreciate the that insight. That was a question I had. All right. So with that, that concludes the hearing for Senate Bill 530. We'll now move on to Senate Bill 524. The Attorney General. Mr. Attorney General, you're up.
Thank you very much, Mr. Chairman and members. This is another easy one. Okay. This Senate Bill 524 is designed to bring accountability and fairness to Maryland's law that allocates responsibility for environmental damage when suits against multiple polluters are settled. And just to be very clear, this bill only applies to industry-wide pollution claims that the state of Maryland brings, usually in its parens patriae capacity on behalf of all Marylanders. Specifically, it only applies to state claims for pollution by oil or petroleum products or by hazardous waste. It does not relate to any private party actions. It will apply to one of the state's large pending cases. It's a lawsuit for contamination by MTBE. It was a gasoline additive in the 90s. And in that case, there are 62 defendants. Under existing law, when multiple polluters damage resources in Maryland, liability is apportioned among polluters for settlement purposes pro rata. And the way the courts have interpreted that is that they do it per capita. So if you have a suit against 10 polluters for causing oil pollution, a settlement with one party will reduce the responsibility of the remaining parties by 10%. This is true whether the settling polluter's contribution to the damage was 1% or whether it was 90%. It lops 10% off the remaining liability. What this bill would do would be to create a standard that we think is fairer and more reasonable. The standard set in Senate Bill 524 would hold polluters accountable for the share of damage that they actually cause or contribute. That's the way it works in the vast majority of our sister states, and it's the way it works in federal cases. The allocation formula that's established by this bill is consistent with the principle that polluter pays, and large polluters will not receive a benefit when smaller polluters settle. So under existing law, if the total liability of a polluter who caused 80% of the damage would be reduced by 10% in the case with 10 polluters. It would be reduced by 90% if all 9 of the other small polluters settled. That means that the company that caused 80% of the damage would end up only paying 10% of it. If you adopt the version of Senate Bill 524, and incidentally, we've submitted sponsor amendments to clarify a couple of points and fix a couple of points. But under this bill, when you settle a smaller polluter's claim, the large polluter's share of responsibility remains at whatever it is that polluter caused or contributed to. Now, when we originally wrote the bill, we were trying to make it as close to federal law as we could, and we included a provision that said that if you settle a case, you can turn to another polluter and ask for contribution. And I know that caused a concern for Ellen Valentino, and we have changed that provision in the amendments to make clear that the opposite is the case, that somebody who settles cannot turn around and seek contribution from another party. Under Maryland law as it stands today, and this would be true whether or not you pass this bill, anybody who's been sued for pollution can reach out and do a third-party complaint against somebody else who caused or contributed to that pollution. And it is, as far as we know across the country, the experience is that nobody in these oil pollution cases brings in gasoline stations. The large polluters are the ones who are selling to the gasoline stations. And even though the gasoline stations may cause a tiny bit of pollution relative to the total amount, it's not worth it for the state to bring them in because their responsibility is so limited. And it's not worth it for the large oil companies to bring them in because they're their customers, and they haven't contributed to the pollution, haven't contributed a significant amount to the pollution. So, we think this bill is designed to be fairer to the smaller polluters. And yet it has generated opposition among those very parties. We think we've taken care of their problem with our amendment. And the amendments also make clear the bill is not retroactive. It will only apply to settlements that the state is involved in after the effective date of the act. So we think overall it's a fair proposition, and especially fair to the smaller polluters. With that, Mr. Chairman, members, I hope you'll give it a favorable report.
Excellent. Thank you very much, Mr. Attorney General. We'll now move on to your panel. First, we have Mr. Mueller. John, you're up. There you go.
Good afternoon. My name is John Mueller. I am the Vice President for Litigation at the Chesapeake Bay Foundation. Thank you for the opportunity to address you in support of Senate Bill 524. Before coming to the Chesapeake Bay Foundation, I worked for the United States Department of Justice for 17 years in the Environmental Enforcement Section, And my job there was to manage and litigate cases referred to the department by the Environmental Protection Agency and other federal agencies. Most of those cases, I would say, were hazardous waste cases governed by the federal Superfund law. Superfund gives the government some powerful tools to resolve cases and to structure settlements in a way that achieve maximum cost recovery. So the EPA goes out, hires a contractor to clean up a site. It wants to recover its costs for having to do that cleanup and for any damages to natural resources, fish, birds, plants, whatever. It can recover those costs. The majority of those cases were resolved through settlement. And Maryland law is a lot like Superfund in many ways, except for how it treats settlements. So for example, the General Assembly has authorized MDE to address pollution caused by other people. And you spend taxpayer money to clean up those spills of hazardous waste or oil. And by law, the General Assembly has directed the Attorney General to recover those costs on behalf of the taxpayers. Unfortunately, Maryland law requires that settlements be accounted for on a pro rata basis, as the Attorney General just explained. Superfund does not have that requirement. Parties can settle for their proportionate share without limiting the government's ability to recover the balance from the remaining parties. So for example, you have a spill in the state incurs response costs, and it turns out there are 10 potentially responsible parties. 5 of those parties each contributed 1% to the cost of the response. And the 5 other parties contributed the remaining 95% of the cost. Under Maryland law, if the Attorney General wants to settle out with the smaller contributors, the 1% group, it's really settled for half the cost. So he can only recover the remaining the remaining amount from the other remaining parties. So it's forfeited 45% of its cost. Now, under the proposed law, if the Attorney General settles with those 5 1% contributors, the state's only resolved 5% of its costs and can recover the remaining 95% from the other parties. The settling parties are protected from contribution claims by the remaining parties. That's really a great feature, and it drives settlement. The current law is actually a disincentive to try and get those smaller parties out from under the cost of litigation, out from under the time and expense associated with that. Requires the Attorney General to spend more time trying to litigate a case with multiple parties. I've been involved in cases where you have 40 different defendants. One may have only contributed 1 drum, whereas others may have contributed 100 drums. You don't want to have 40 defendants in court. You want to just have the top ones that were refusing to pay and litigate that case. Settle out with the smaller ones, save the government money, save taxpayer money, and get maximum cost recovery. We believe the Attorney General should have the strongest and most equitable legal tools available to recover all the costs associated with a hazardous waste cleanup. And for these reasons, the Chesapeake Bay Foundation supports Senate Bill 524.
Excellent. Thank you, Mr. Mueller. We'll now move on to the panel, the opposition panel. I think Mr. Kemmerer is not here. Actually, is Mr. Snyder? Nope. Oh, that was you. Okay.
I am, but I'm not with the opposition. I'm with the Attorney General.
Yes. Sorry, I didn't bridge that segue back. So we look back, Mr. Snyder. I saw Hannibal wasn't here, so I saw you were there. So yes, representing the Office of the Attorney General, Mr. Snyder, you're next.
I have nothing to add to what the Attorney General and what Mr. Mueller both said on behalf of the bill. I think they covered the ground very nicely. I'm principally here in case there are questions that require my input.
Okay, excellent. With that, that'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel, and we'll start off with Mr. Ferguson.
All right, thank you, Mr. Chair, members of the committee. Colby Ferguson on behalf of Maryland Farm Bureau, and This is not one that we would normally come in on, and honestly, we did not testify on this bill in the House version, but after listening to the bill hearing in the House and kind of listening to and then really reviewing what this bill would do, we have some serious concerns with what this bill would actually create. And I know that the Attorney General brought up about to correct the component in there that would not allow a larger group to to then go and sue some of the smaller people underneath them. But what we're really worried about is that the way that these are set up is it's the Attorney General's office uses trial lawyers on a contingent fee basis, and when you have them basically ponying up the cost of a trial until they get to the final suit is as paid, they don't really make any money. And so all of a sudden, if now you make it where the small guy can actually now be included and be excluded quicker at a smaller fee, the net is going to be thrown in a wider swath. And so I think Mr. Mueller kind of alluded to it when talking about if there was only a couple of 1%ers or a handful of 1%ers that could get out of it quicker, then that would be good. And so as somebody that represents farmers, 99% of the time, we'd probably end up being a small, if any at all. And the concern that I have is that, if all of a sudden now we got swept into a large case of whatever it might be from whatever type of pollution, this is not just an MTBE bill. That's the front of this bill, but this bill would be used in other cases down the line that would look at water pollution. So whether it be a phosphorus issue or maybe it's an issue with a CAFOs or whatnot, our real worry is that this would allow that net to go out, and then the farmer's just not going to be able to afford a large case and a large cost, and is going to probably look to settle. And we just kind of look at it as these trial lawyers, it's kind of their fees to pay their fees and kind of help pay to keep the big one going. So we would oppose. Thank you.
Thank you very much. All right, next we'll have Mr. Campion.
Thank you, Mr. Chairman. For the record, Lewis Campion, Maryland Motor Truck Association, here in opposition. And I do appreciate and want to acknowledge that some of the concerns that had been previously raised over the right of contribution that were in the original bill, that the Attorney General's office has tried to address those concerns. But we still think this is a very complex piece of legislation with a lot of uncertainty and numerous questions. We're just not certain, for example, under this legislation, who determines the proportionate share in a settlement if this case hasn't gone to trial, or if it's ongoing in trial? Who's the fact finder in those instances that would assign the liability here? We're just not sure. Is this going to ultimately, to Mr. Ferguson's point, increase the number of either defendants in lawsuits or increase the number of lawsuits overall for the purposes of trying to force settlement? And then, this was a significant conversation, I know, in the House about, are we in fact changing, the liability statute by introducing this concept of comparative responsibility as opposed to the contributory negligence standard that is in the law today? So do I believe that the AG wants to sue a lot of small Maryland businesses? No, I'm not suggesting that is his intent, but we're just not sure how substantial the introduction of all these changes could potentially be, and just how broad this is, to Mr. Ferguson's point. And so that's why we are here in opposition of this legislation. Thank you.
All right, excellent. Thank you very much. We'll now move on to Mr. Pica.
Thank you, Mr. Chairman. I have not had a chance to read the Attorney General's amendments, so I can't necessarily discuss opposition to the bill. I will say I represent rural farm stores, and they are a distributor as well as a provider of gas at gas stations. I'm more concerned about their liability as a distributor. Right now, if there is a gas spill, you have the right to sue, like was done in the Jacksonville case 5, 6, or 7 years ago. And those cases were all resolved. That case went to the Court of Appeals, and liability was resolved in that case. I'm concerned about a joint tortfeasor who settles, who then tries to recover a right of contribution against a distributor. The distributors did not put MTBE in the gas. That was done by manufacturers. If they want to seek a right of contribution against other manufacturers, I have no problem with that. But we might be subject, distributors and trucking companies like Mr. Campion represents, could be subject to strict liability. If one of those companies, his companies or my client is negligent, they can be sued under existing law. So he was right. Mr. Campion's right. There's a lot of uncertainty with this bill. It's very complex. And if you go on, and if I were the senator from the 41st district, for example, I'd wonder why we can't do this for lead paint. At least in her, if I may use her name, in Senator Carter's prior legislation, that would allow it to go against the real wrongdoer, the manufacturers of lead in paint. This bill works the opposite direction and would allow a joint tortfeasor to recover contribution from one who may not have put the MTBE in the gas. So this is a very complex bill. I go back to this legislation on joint and several liability a long, long time back. These bills have been in every year. Why not open it up? If you're going to open it up for joint and several liability, you should do it for everybody, not just a narrow set of 2 cases. So I served with the Attorney General in the Senate, and when I testified in the House, he kept shaking his head every time I testified. So, because he thought I was wrong. So I know he knows how to read a bill, and I'm pretty sure he knows that I know how to read a bill. So this is very complicated. I don't know that you have enough time, given the restrictions in this session. So I'll conclude with that, Mr. Chairman. Thank you. Thank you very much.
Thank you. Thank you very much, Mr. Speaker. The history runs deep. All right. We'll now move on to Mr. Gorski. I'm going to ask to, there you go.
There we go. Thank you, Mr. Chairman. I appreciate your time. Thank you, committee members. Anthony Gorski here on behalf of the Mid-Atlantic Petroleum Distributors Association in opposition to Senate Bill 524. And I want to touch on a couple of things that you've heard here today. First, I think one of the clearest things to stress is that it's not appropriate to compare this bill to the quest for cost recovery in situations like Superfund. In the Superfund case, you're cleaning up at the federal level that was spoken about. You're cleaning up a specific site, and you have a parameter established as to what that site's going to be. The lawsuits that we're seeing, particularly we can use the MTBE lawsuit that currently exists, is on a much broader context. It's a statewide pollution issue. There is no set site that needs to be cleaned up based on that. And so it's not clear who has what share, who has what apportionment. And so when you look at the bill as it's written, and even with the amendments, the only thing the amendments really did was strike out the notion that someone who settles can then seek contribution. And that is gone. We acknowledge that. However, the complexities of the liability schemes are the problem, because when you get into the bill and look at it, what you see is that you have various things that are supposed to be occurring in the legislation by fact finders. And yet in Maryland, there is no system for a fact finder prior to a trial. If you don't go to trial, you don't have a fact finder. There are no facts established. Likewise, you don't have an apportionment of a comparative responsibility is the term that's in the legislation. There is no comparative responsibility because the total amount owed isn't established yet when you're settling a case. These aren't cases where the state is saying we're owed $50 million. the complaint in these cases is not pursuing cost recovery. It's pursuing a yet to be determined amount of time or amount of money. And so when the state goes before the court, it's going to get a number that's established. There is no, if the party settles and goes in a tort sense, if a party in these tort cases, like the MTBE case pending now, if a party goes and settles ahead of time, it's not going to be in front of the court. The court's not going to be assessing a proportional liability for a party who's not before it in a tort case. And so that's one of the complicated problems with the bill. It combines the notion of statutory remedies like cost recovery with tort claims. Yes, it absolutely does do that. And so when you look at the complications that can come from a bill like this, the problem is that you really don't know how there's going to be a fact finder to make these establishments. And you also don't know things, for example, in the bill, it offers the idea that there is a, my apologies, a proportionate share of comparative responsibility. Well, proportionate share is defined to be a percentage of comparative responsibility, but comparative responsibility is not defined anywhere in the bill. And it's not a term that exists under Maryland law at all. And so who's going to establish that? You're putting a situation together where you present this, I guess it would be an objective to work towards settling these cases to the first trial court that has to deal with this statute. And all of these things are going to have to be answered by a judge, a trial judge, maybe a federal trial judge. It might not even be a Maryland state trial judge. And so there are so many complex parts of this, not because the bill itself is written in a complicated fashion, but because it leaks in these various new terms and concepts that aren't established in Maryland law. And so it's setting into motion the problem that you're going to have a vaguely worded and somewhat confusing statute that trial judges are going to have to interpret and apply. And then it's going to go to the Court of Appeals. And sometime 10 years from now, what's going to come back to the legislature is, why didn't you give us more guidance on how to do this? There are no definitions in this statute. The Attorney General's submitted written testimony said that the bill provided an allocation formula. There's no such thing in this bill. It doesn't say that at all, but that's what his testimony said. And so it's not appropriate. The only thing that the problem, again, looking at this from a bigger perspective, the problem is with this bill is that you have to pretend that there are fact finders that make these decisions before trial so that there can be some apportionment of this
Mr. Grosky, sorry, my apologies. You're over time. I didn't hear the timer.
Oh, I'm sorry. I did not hear that either.
No
I'm sorry, Your Honor. I'm sorry, Mr. Senator. And so, Mr. Chairman, I would submit that the MAPDA is opposed to the bill. We'd ask that it not be reported out of committee.
Okay, excellent. Thank you very much. So I think we have a few more here. Actually, no, that's it. With that, that concludes the testimony for Senate Bill 524. We'll now switch over to the committee for questions. I saw Senator Lee first, and then Senator Bailey, and then Senator Huff. So Senator Lee, you're up.
Okay. Thank you, Mr. Chairman. Can you hear me?
We can.
Well, it appears that the way the state currently recovers, it is really inefficient, if not time-consuming and laborious, and maybe bordering on being unfair. So without this legislation, the ability of our state to pursue fair liability of all parties is rather limited, I think. But I think this bill kind of provides some guidance, and actually it doesn't look too complex to me. But perhaps if the Attorney General or Mr. Mueller can respond to this question about how this legislation would be able to remove some of those obstacles.
Thank you, Senator. Thanks for the question. Let me see if I can clarify some of the concepts that have been raised by the opposition. First of all, what this bill applies to are settlements. It doesn't change who's liable. Anybody who causes or contributes to an oil spill, who causes or contributes to hazardous waste being put in the environment is liable in Maryland and pretty much across the country as far as I know. So this doesn't change that. It doesn't change the fact that anybody who causes or contributes to one of these events of pollution is jointly and severally liable. That remains the case. What it changes is how that liability is allocated when some of the parties settle. And right now, it's, as I've said and John Mueller has said, that's per capita. And what this bill does is says, no, that's going to be based on the comparative allocation of responsibility. So hypothetically, you have one huge oil company that contributes 90% of the pollution. Under existing law, if you settle with 20 other defendants, that that polluter's liability is going to get chopped by, well, let's see, it'd be like 98%, close to it. If you pass this bill, you settle with the other defendants who contributed a smaller amount, there will be a fact finder at trial. The fact finder is the judge or the jury, depending on whether the parties have asked for a jury trial. So the fact finder will then say, well, okay, let's see, you know, these parties that settled in total contributed 10% of the pollution. So we are going to whack that off the responsibility of the remaining major polluter. And that polluter's responsibility is 90%. If you go by existing law, at that polluter's responsibility is hacked down by a per capita amount, depending on, you know, which defendants have settled. It can go down to next to nothing, despite the fact that the remaining defendant contributed the vast majority of the pollution. So it's fairer to the small defendants because they get divested of all responsibility. Nobody can look back to them and say, hey, you know, you didn't pay enough. They may pay $1 to get out of the case. They're out of the case for $1. And then the court later on, the finder of fact, will say, well, you were responsible for 1% or 10%. You got the deal of the century. You only paid $1 and, you know, you're out, but we're lopping off 10% of the responsibility of the remaining defendants or defendant. So it doesn't change the law with respect to joint and several liability. It doesn't create, you know, comparative negligence versus contributory negligence. This isn't a negligence case. The two statutes that we're talking about are strict liability statutes. So it doesn't change comparative. It doesn't change Maryland's existing system of contributory negligence to a comparative negligence standard. It just lets the small defendants out of a case. If you don't change it, then the state has a perverse incentive. The state won't settle with small defendants because it takes too much off the back of the major polluters. And I think it's notable, you know, because I mean, you've heard from truckers and you've heard from farmers and you've heard from gas stations. None of them have been sued in the MTBE case. They haven't been sued by the state. They haven't been brought in as third-party defendants by any of the other defendants. There's 62 of them. Not one has filed a third-party complaint against a gas station or a farmer. And the state has no incentive to do that, and neither do the other folks for the reasons that I mentioned earlier. So it's an advantage for minor polluters. It doesn't, I mean, the state could have brought them in if it had wanted to. So could the other defendants. Sorry if that was too long an answer to a simple question.
All right, excellent. Thank you very much, Senator Leon. Let's move over. So all right, Senator Bailey, you're up.
Thank you, Mr. Chairman. Good afternoon, Mr. Attorney General.
Afternoon, Senator.
Couple quick questions, and you can help me walk through this. Trying to, I understand, and I was listening to Mr. Campion when he was speaking. So the court, is that actually who you would describe as the fact finder?
Yes.
So in order to have a fact finder, we would have to be in court to do that?
Yes, this only relates to cases that are in court. Or
okay.
it could happen before the case is brought, but ultimately the fact finder, the judge or the jury, would make the comparative allocation.
And reading the amendments that you proposed, does altering your first amendment, does it alter the incentive for an early settlement, which seems, I mean, I think the way I understand it before you put your amendment in, it really did, it concerned me about due process. And it was like the first one to the table. But, you know, working in the federal system, I'm very familiar with that queen for a day and how that process works. And it works great for the state, but sometimes it doesn't work good for somebody that might not have been informed. It might not have an attorney that was ready for that. And I just wanted to understand how your First Amendment dealt with that, and if it made it seem simpler for me, like more due process would apply.
Senator, I think this change to the law protects everyone with due process. It takes away nothing that they have now. It gives them, and I'm now talking about the smaller contributors, smaller polluters, it gives them advantages that they don't have under existing law. It creates more of an incentive for the state to settle with them, number one. And number two, it prohibits somebody else who settles from turning around and bringing in either a third party or asking for contribution from one of the remaining defendants.
And my last, thank you very much for that. And my last question is, you know, at home, we have had some spills in the past. And when we had, some of them have been, you know, with Chalk Point, some have been at service stations, some have been at residences. People have worked with MDE and they worked alongside MDE to meet all the guidelines to make sure that they followed every rule that there was. But now, as testing has become better, and there is you know, different cleanup ways that exist now that, quite frankly, 10 years ago weren't in the rules. All of a sudden, if we realize that some of the things that even somebody did a few years ago and they met all the standards, could they then be a party to one of these suits for contributing if they followed the rules that were in existence then? Does this at all change that?
This does not change that, Senator Bailey. The two statutes that this impacts, the hazardous waste statute and the oil statute, are both strict liability. So, you know, if you were walking across the field with a can of gas and you tripped and spilled it, even if you're not negligent, you're liable for whatever damage that can of gas caused. And you know, nobody's pursuing that kind of a claim, but it's a strict liability system. This change to the law doesn't change somebody's liability for what they did 10 years ago. If they met all the standards 10 years ago and they are liable for suit now, this wouldn't change it. If they're not liable for suit now, this wouldn't change that. But in some cases, if they haven't reached a resolution with the Department of Environment, they might continue to have liability, but this bill doesn't change that.
Thank you.
Thank you.
Excellent. Thank you, Senator Bailey. All right, we'll move on to Senator Huff. You're up next.
Yeah, thank you very much. I I should say good evening now, Mr. Attorney General.
Good evening, Senator.
My concern, Western Maryland, we've got a bunch of small distributors. So, you know, I used to think of distributors were like Exxon, big folks, but we got a bunch of, I guess they were the middleman. They're, you know, they're very small businesses. They're not much different than a gas station or whatever. So, and so you were saying the bill doesn't include gas stations now. It doesn't, you don't think it affects the farmers or the others, but what about, are the distributors are still leaving these small folks? Are they going to be on the hook, or how does that work?
What Senator Huff, when I was saying it's not going to impact the gas stations, the farmers, et cetera, what I mean is, you know, it doesn't change their liability. They haven't been sued in the MTBE case, and they're not going to be. There are distributors who are defendants in the MTBE case. I don't know where the cutoff was, but it was at a point, I believe, where we had significant distributors who had actually caused a significant amount of pollution. This bill doesn't change the liability of distributors, and it does change the allocation of responsibility after they've settled. That's the only thing it changes if they're in the case.
I guess my concern is, and I think distributors are all different. I mean, some of them are obviously very large, but some of them I know for a fact are very small.
Right.
And so in their cases, so your claim is that in the cases of the small distributors, you think that with your amendments, this will actually help them and that they'll pay less?
Yes. I mean, so first of all, in the state would not sue small distributors unless they cause some significant amount of pollution, and even though it's strict liability, unless there were some recalcitrance to take responsibility for the pollution that they caused. But again, it doesn't change the liability of distributors. It would make it easier on all small defendants, because right now, if they're in the case, the state has a reluctance to settle. I mean, to be blunt, we've been approached by smaller defendants in the MTBE case. I can't say much more than that, but we've been approached, and we've settled no claims. The state has disincentive to settle a small claim because it chops too much off the ultimate responsibility. Thus, you know,
it's kind of an interesting contrast here, because the and I haven't read your amendments yet, that your stated reason for the bill, and I believe that is to help the small people, and then the small people are all in here.
Yes.
Opposition. So yes. maybe we could work this out and all come to I think it sounds like we're all want the same thing, but I don't know. There seems to be some disagreement over right now.
You know, I mean, I do think there are some misconceptions about what the bill does, but it's notable, you know, none of the parties to the case are in here saying you got to stop this. Those are the people that we're suing.
All right. So if it's okay, Mr. Chair, I would like if I could ask John Pico a question. I'd actually just like his response, because he was the one that brought up the small distributors, and I'm trying to figure out where our disconnect is, because, you know, the Attorney General's side is, hey, this will help. If you're a small distributor, one of these small shops out by me in Western Maryland, you could actually walk away with less, and Exxon or the big guys take the bulk. But your testimony was the opposite of that no, it's going to hurt these small distributors and folks.
Well, we're concerned that it could. So my client, Royal Farms, picks up gas from a manufacturer or wherever they receive it, and they truck it to their stations. I'm not aware of any lawsuits against them right now. And I'd be concerned that a settling party could seek contribution from them under certain circumstances. Right now, if you settle a case, you cannot under current law, you cannot seek contribution from a party that hasn't settled. And that seems to be working fine right now. This opens up new type of a new theory of responsibility. And like I said, these bills have failed every year for 25 years. And we're opening up in a narrow circumstance. So I'm concerned that even if one of these small companies, Senator Huff, even if one of these small distributors or my client is not even in the lawsuit, that a settling party can then seek contribution from them, even if they're not sued and part of their current or the pending litigation. And that's something I think the Attorney General can straighten out right now. So that's my main concern. And maybe he can address that right now as a response to your question.
I mean, I don't, if he wants to respond, yeah, I'm more than happy to. I don't want to expect the chair and set up a back and forth, but yeah, if the Attorney General volunteers to, I'll be happy.
So, Senator Pica hasn't seen the amendments, and there was a provision that gave concern to the smaller contributors, polluters, whatever you want to call them, and we fixed that. And basically we inserted the word "not." So I don't know what page it's on in your amendments. On mine, it's page 3 at the top, and it's subparagraph E. Subparagraph D. And it says, a person responsible for the discharge who has resolved the person's liability to the state in a settlement or through satisfaction of a judgment may not seek contribution from any other person responsible for the discharge who is not settled with the state. We inserted the word "not" because that paragraph gave concern originally to the gas station owners. So, it's completely the opposite of what it was in our original version. And I say we had it in that way because we were trying to be as close to the federal law as we could, and that the federal law has that provision. So we decided under Maryland law right now, a settling party cannot seek contribution from somebody else, and nobody else can seek contribution from the settling party. We'll just keep it the same in this version, and in that way we differ from the federal law. But I think that's the provision that Senator Pica is concerned about, and it's now that they may not seek contribution.
Okay, I just one last question, then I'll throw it back to Senator Pica. Then, if you all and everyone, the folks on here, Colby and everybody else, could look at the amendments and let us know if you still have concerns that satisfies. With B, I mean, does that, John, does that assuage you at all or no?
Well, I have to read the amendments, and I think it would be a good idea for me to discuss this with Ms. Valentino and Mr. Campion and others. So I have to fit the amendment into the bill.
Fair enough.
And I'm assuming the committee's going to work on this. We don't like the bill. Let's make that pretty clear.
Okay.
But we need to take a look at the amendments and out of fairness to the Attorney General.
Okay.
Okay.
All right, excellent. All right, thank you, Senator Huff, and thank you for the colloquy between Senator Pica and the Attorney General. All right, further questions from the committee? All right, seeing none, that will conclude the hearing for Senate Bill 524. We'll now move on to our last bill of the day. Senator Zucker, good to see you. Have a great afternoon. Have a great weekend. All right, excellent. Senator Zucker, you're up next with Senate Bill 592.
Well, thank you very much, Mr. Chairman. For the record, Senator Craig Zucker here in support of Senate Bill 592. I got my hint both from you, Mr. Chairman, and Senator Huff when he said good evening. So this bill that I'm presenting has no opposition, so I will keep my testimony very short. back in 2015. At that time, Delegate Croza and I, when we were in the House of Delegates, along with some other delegates, created a child welfare reporting system back in 2015. And based on where we are currently, this is just updating that with just keeping an eye on a very valuable population, but vulnerable, with just getting updates on mental health, how they're doing in school. Mr. Chair and colleagues, the Department of Human Services had suggested amendments. We think they're clarifying. They should be in your folder. With that, it should be a kumbaya. The Department of Human Services is supporting this. And they also mention, I believe in their testimony, that this legislation is important also to make sure that we're keeping in step with the federal Every Student Succeeds Act. I would just make note that the cross file that passed out unanimously is in the House bill, which is 258, is in your possession as well. And with that, since I know the evening is late, I'm happy to answer any questions or put it over to the panel.
All right, excellent. Thank you very much, Senator. All right, so for your primary witness, I have Ms. White, but Ms. White, you are here. You're up. So
yes.
The primary witness, you'll have 5 minutes.
Okay, I won't even need 5 minutes, but
okay.
My name is Rachel White, and I'm the Child Welfare Policy Director at Advocates for Children and Youth. And I just want to thank you for allowing me to present testimony on behalf of Senate Bill 592. I also am representing the Coalition to Protect Maryland's Children as well. And as Senator Zucker indicated, the Child Welfare Data Bill requires the Department of Human Services and the Maryland State Department of Education to report on specific indicators for youth in foster care. And the data will also be disaggregated by race, gender, geographic region, and age, which allows advocates and other stakeholders to actually look at the data and create targeted interventions that will help to reduce racial disparities. And so, as Senator Zucker mentioned, this has already been passed out of the House, and so we ask that you issue a favorable report in the Senate as well.
Excellent. Thank you very much, Ms. White. Next, we will move on to Ms. Lamont. Ask to unmute you in the corner there. Thank you. There you are.
Sorry. Thank you. Good afternoon or evening, Chairman Smith, Vice Chair Wallstreicher, and members of the Judicial Proceedings Committee. My name is Erica Lamont. I am the Director of Advocacy for Children's Rights at Maryland Legal Aid. We represent thousands of children in foster care across the state of Maryland. Senate Bill 592 will assist in collecting data, which can be used to analyze, verify, and measure the effectiveness of services and inform policy and practices to improve outcomes for the families that we serve. In our written testimony, we highlighted a client we will refer to as Aaron, who was removed from his mother's care. The 7-year-old has learning disabilities and speech delays and required an evaluation for special education services. Because of the different placements, Aaron attended 4 different schools, and as a result, his much needed evaluation was delayed. Aaron's situation is not an anomaly. Knowing how many foster children have the same or similar experience is just one example of how SB 592 can help create practices that will have positive outcomes for foster children all over the state of Maryland by giving us much needed information for data-backed improvements in policy and training. We shouldn't make decisions on assumptions when it comes to the lives of children in the child welfare system. Some of the most vulnerable residents of Maryland, and if we do fail them, we fail ourselves. Data is not typically exciting, but when we are looking to make informed decisions, we need to have the appropriate information. To make evidence-based practices, we need sufficient evidence. And for these reasons, Maryland Legal Aid supports Senate Bill 592 and asks for this committee to give it a favorable report. Thank you.
Excellent. Thank you very much. All right. And with that, we'll go on to Ms. Calfini.
Calfini. Good evening, Chairman, Vice Chairman, and committee members. My name is Natasha Calfini. I am a staff attorney at the Office of the Public Defender in Maryland in the Parental Defense Unit. We represent parents whose children are either have been removed or are at risk of being removed from their care and placed in foster care. we are in support of Senate Bill 592 with amendments. We did submit written testimony with our amendments. I wanted to just give a little testimony as to why we believe the amendments are important. Our clients are only entitled to representation when court action is being petitioned, when Senate petitions are being filed. We would like for the amendments to include amendments that would allow for data to be collected to determine the number of children who are being removed from the home prior to court action being filed and before their parents are allowed representation. We believe collection of this data will inform policies and procedures that would allow for parents to have representation and to get legal advice prior to the removal, which would increase the number of children who are able to stay with their families, as well as only remove children where it is absolutely necessary for their safety. In addition, our last amendment is asking that data be collected and kept track of children whose parents' rights are terminated, but they are not adopted. And this information would go to ensuring that children are actually receiving permanency and not lingering in the system as legal orphans at some point. So we are in support of Bill 592, and we would ask for a favorable report with those amendments included. Thank you.
Excellent. Thank you very much. All right. With that, that concludes the testimony for Senate Bill 592. We'll turn to the committee for questions. All right. Seeing no questions, that'll end the hearing for Senate Bill 592 and the hearings for the weekend. Thank you, Senator Zucker, and thank you to the panelists. Have a good weekend, everyone. And to the committee, this has been a long week. Congratulations on making it through, and enjoy your weekend. And I'll see you all on Monday. Have a good weekend. Thank you all.